Hello, this is Matt on the Moon Lambo channel. Today, there were some legal happenings in the world of XRP, and the entire community on social media has been talking about it. And so I'll just tell you here at the outset of this latest Moon Lambo hot jam, there's one very well-known attorney within the XRP community who is warning, as a result of the most recent development, that a jury actually could find XRP to be a security. This would be in a new trial, separate from the SEC v. Ripple case. Now, I say new trial because it will be, but the new trial will be stemming from a very old lawsuit, actually dating back to, I think it was 2018. If you don't know what I mean by that, don't worry, I'm going to get you all caught up to speed here. But there's some diverse opinions on this, I think it's safe to say. There are a couple attorneys, and I think I read them correct, and I think it's safe to say that their perspectives are that it won't be the case that XRP, no matter what happens, even as a result of what occurs in this new trial, however it unfolds, it's not going to be the case that XRP itself would be found to be a security, and I'll explain why. And that includes perspective from yet another attorney who is in the XRP community. So plenty to break down here. But before going further, I do want to be clear, I do not have a financial background of any kind. I'm not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so I'll tell you, it took me quite a while to get, to wrap my head around this, because I had to refresh myself on some stuff that happened, like a year or two ago, because this legal happening has been going on since the end of 2020, and it's now 2024. And it's also a little bit challenging with me not actually having a legal background. So I'm a lawyer, but I only play one on YouTube, so not in real life. I'm not a lawyer in real life. I think I finally got my head wrapped around this sufficiently that I can report to you, and I'm sure there's going to be more developments and more opinions, so I'll be happy to make new videos as perspectives and news continues to come out here. But I will tell you, one of my biggest questions was, what does this mean for the typical XRP holder? And thankfully, a couple attorneys were kind enough to respond to some of my queries on social media platform X. And so there was this story from Coindesk titled, "California Judge Breaks with New York Counterpart, Sends Ripple Securities Lawsuit to Trial." And so this isn't actually all bad. In fact, you could argue, it's true, Ripple got some wins here. But before running through this article, I thought what I'd do first, because I do want to get to the heart of the matter, is let's talk about the legal status of XRP, because as you all know, XRP gained legal clarity on July 13th last year, almost an entire year at this point, known now as XRP Victory Day. And so why are we even talking about this in June of the following year? Well, here is a post, it's a thread from XRP community member and attorney Fred Rispoli, and he was just sharing his perspective and just kind of warning, hey, we need to keep pushing back against this. And he was warning that XRP could be found to be a security in this particular lawsuit. And just to be clear, the lawsuit that we're referencing, it's the one dating back to, again, I believe 2018. This is not the SEC lawsuit. This is the class action lawsuit. You may recall that there's an individual. There were a number of people named in this, but there's one guy that stands out, and he was claiming that I think he lost something like $600 or something stupidly small investing in XRP. It's like he bought XRP towards its peak, near its all-time high, over 6 years ago, and then something like maybe 2 weeks later he sold at a loss, and so then he wanted to blame Ripple. It's dumb as hell. It doesn't make sense. The dollar figure wasn't even there. It's always been suspect that he'd even bring charges against Ripple in the first place, but anyway, is what it is. So it's a class action thing. And so anyway, here's what attorney Rispoli had to say. "Win for Ripple in the Oakland class action. Judge grants Ripple summary judgment motion on federal class claims for unregistered securities, as well as the state law securities claims. But these were procedural wins. The class action is now over at the district court level. As to whether XRP is a security, however, the court held it is for a jury to decide whether all three prongs of the Howey test are met. That claim, a individual claim by one plaintiff will go to trial. In all likelihood, will settle given the extremely low damages and very bad jury verdict that could result if plaintiff wins. To sum up, court says whether XRP is a security in the context of retail buyers on an exchange is for the jury to decide and not a matter of law. Ultimately, crypto world needs to keep pressure on getting federal legislation because we are on track to having XRP be a security in California, but not in New York. And so he's kind of, ringing the alarm bells here, effectively stating, hey, of course we know that XRP has legal clarity in New York at that level, but in California with this separate class action lawsuit, which again is nothing to do with the SEC lawsuit, the judge isn't quite agreeing, and I'll show you exactly why that is. But this has caused some concern and confusion, and that's not some sort of dig against Frederick Smollett. The whole situation is highly complex. So as soon as I read through that, and mind you, I've been following this literally for years and reporting on it. I was like, okay, what are the implications of this? And then I had to go back. Okay, what led up to this? What were the various opinions of various cases? And it was a whole thing. It took me some time to get caught back up to speed because some time has passed here. And so I wrote to Attorney Smollett and I just said, hypothetically, what are the implications of Judge Torres finding XRP itself is not a security, but a California jury finding that XRP is a security? What would that mean for the typical American citizen in any random state? And so, folks, I typed that because I thought that's probably what most of you listening care most about and are most curious about. And so I wanted to get to heart of that. And I did end up getting some additional clarity. It took some time, but thankfully, a couple of attorneys did end up ultimately responding to me, including XRP community member and attorney Bill Morgan. He responded to that and he said, the potentially different holding, so that means he just means decision from the court, and I needed to clarify what that meant in a separate post because look, it's lawyer speak, and I was like, through context, I was like, okay, so he's talking about the opinion of the judge, and yeah, that's pretty much it. It's the ruling from the court, which came from the judge, basically. So that's what he means by different holding. So he says the potentially different holding ultimately would be on programmatic sales. Judge Hamilton did not apply the holding of Judge Torres on this issue. Okay, so that is an important takeaway. Now, the programmatic sales, you'll recall from Ripple, and that's actually a term that Ripple came up with, and then the SEC ended up using it in the lawsuit, which resulted in the judge using it in the SEC v. Ripple lawsuit. That's why the word programmatic is being used. We're talking about Ripple's sales of XRP that ultimately ended up on regular cryptocurrency exchanges where people like you and me could purchase it. Now, mind you, of course, you and I, if we're buying that XRP, we don't know it's coming from Ripple. So kind of hard to be in an investment contract with Ripple if we're buying and we don't know who the hell it's from. And so that was one of the things ultimately that was to, I'd say, every XRP holder's benefit when it came to the SEC v. Ripple case. But Attorney Morgan ended up sharing this screen grab from the decision today, the class action lawsuit in California, and the judge in that one, that's Judge Hamilton. And so Attorney Morgan shared this and wrote, this was Judge Hamilton's quoting of the holding she did not follow for the purpose of Ripple's summary judgment motion today. And so Judge Hamilton shared this, and it shares a quote of what Judge Torres wrote in the SEC v. Ripple case. So the screen grab reads as follows. The Southern District of New York Court's ultimate holding on the third Howey prong was that, quote, and so now this is the part from Judge Torres, quote, it certainly may be the case that many programmatic buyers purchased XRP with an expectation of profit, but they did not derive that expectation from Ripple's efforts as opposed to other factors such as general cryptocurrency market trends, end quote. And so you'll see as we go a little bit further, and this is brought up by Attorney Morgan, there's different evidence in each of these lawsuits anyway. So as far as what moved the price of XRP, seems to be the case that there's different evidence in front of Judge Hamilton than there was in front of Judge Torres. So that's a factor to consider as well. Also, as far as my question when I wrote to Attorney Rispoli asking, hey, what's this mean for the typical American citizen? If you've got Judge Torres saying, hey, XRP itself is not a security, but what if a California jury does find that XRP is a security? Because again, the post that I'm responding to from Rispoli, he is saying there that we're on track to having XRP be a security in California, itself be a security. So that's why I was specifically using that language. I understand that an asset itself is never the security unless it's included in the actual definition of that. Like a stock, for example, by definition, that's a security, like literally by definition. But digital asset, cryptocurrency, so on and so forth, that's not included in the definition, right? And so Attorney Morgan responded to me and he clarified. He said, sales of XRP, not the token itself. And so what he's saying there is, so he seemed to disagree as far as, and I don't want to put words in anyone's mouth, but upon reading that, he was making a distinction there. Because again, Attorney Rispoli said, he's saying that it's on XRP on track to be a security in California if the jury decides that, right? And Attorney Morgan saying basically, no, it would be the sales of XRP, not the token itself. And so fair enough distinction, but still I was wondering, okay, good to get that clarification, but I was thinking at that moment, what does that mean? And so I responded to him and I wrote, this is where I need help understanding. How could a typical XRP buyer, perhaps buying XRP from an exchange, have expectation of profits from Ripple when they didn't even buy XRP from Ripple? Is that what a jury would be deciding in California? And thankfully, and I appreciate this, Attorney Morgan reposted what I wrote there and wrote the following. Let me take a sip of water here. I've been talking like all day. 1 second. All right, so Attorney Morgan responded. He said, the promotional activity of Ripple, which Judge Hamilton may be treating with more weight than Judge Torres could give the expectation. There seems to be some additional evidence of promotional statements before Judge Hamilton. The whole remaining cause of action going forward is based on Garlinghouse's statement, I am long XRP, and that's a quote from Garlinghouse, while selling millions of it, which the plaintiff alleges was misleading. Yeah, and so as an aside, just real quick here, just to share my personal opinion on that, it's true that Brad Garlinghouse was selling XRP, but it was running to an all-time high, and so he didn't sell all of it. Not that it should be any of our damn business anyway, as far as I'm concerned, but it probably became an outsized portion of his net worth, and it makes sense to sell it. Also, you can sell a portion of an asset and still be long that asset. So the fact that he sold some XRP, if you think that means he was lying or that he wasn't long, that in and of itself is certainly not evidence of that. I mean, if XRP goes high enough, I could be sufficiently enticed to sell all of it. But if you're talking about whether or not I think it's going to be worth way more in the future, that's not indicative of what I actually think on that topic. It's about what's best for me in that moment. And beyond that, understand that, and I don't know how many people realize this, but part of Brad Garlinghouse's compensation package, rather than more money and more salary, was that he had less salary and instead got XRP. So that's part of his compensation package, which was more risky, taking on more risk up front, because mind you, when he joined Ripple, XRP was all like half a penny. Nobody, they couldn't have known what was going to come. Maybe a hope, that something crazy is going to happen, but you don't know that. And so he's working, it's part of his compensation package. XRP goes bananas, and you're going to blame him for selling some of it when it's probably an outsized portion of his net worth at that range? You're like, would you really blame him for that? For me, the answer is no anyway. So that's an aside. Just thought I'd mention it. Anyway, Attorney Morgan continues. Judge Hamilton does not seem to be aware of the expert evidence in the SEC matter that XRP price for years seems to be following Bitcoin and ETH in particular, and has little to do with Ripple positive announcements. I believe this influenced Judge Torres, as seen in her reference on market trends when analyzing the expectation of programmatic buyers. Yeah, and so that's certainly true. She did have that information, and it's undeniably the case that XRP moves in tandem with the broader crypto market. So if that's why I cited here specifically Bitcoin, which most obviously leads the market, followed by ETH. Yeah, that's absolutely correct. So did Judge Hamilton have all of that information? Doesn't seem like it. But of course, we still got to get to the main point here, and so I had to do all of this in order, not trying to drag anything out, but we have to do this in order here in order for it to make proper sense and not be more confusing than it has to be. It's already sufficiently confusing, I'd say. But is this something that's going to be horrible for XRP? Do we not have that clarity? Because that's the big question. Do we have clarity or not? If the jury actually finds that XRP is or the sales of XRP in this case, even if it's just the sales of XRP are, those were illegal transactions, what does that mean for us? Well, at this point, based on what I've seen here from these attorneys, probably not. I mean, I don't want that to happen, but probably not a big deal, actually. In fact, take a look at this. So, attorney Mark Fagel, former SEC attorney, was kind enough to respond to me. And this really made it pretty clear. Like he now, mind you, he's a former SEC attorney. He doesn't think that this is a big deal, actually. And he kind of stated it pretty bluntly here. Look at what he wrote. He said, he wrote this to me. He said, I wouldn't overstate the issue here. The California case alleges securities fraud by a Ripple executive. While the court must first address whether XRP was sold as a security to reach the fraud issue, the case will not result in the same sort of relief the SEC seeks in its case. So even an adverse finding for Ripple may have no broader implications. At most, Ripple might decide not to sell XRP in this district. And so that's the worst that he thinks would happen. Maybe Ripple's not going to sell XRP specifically in that district. That would mean nothing effectively to the typical XRP holder. And so, but the key takeaway from this, as far as I'm concerned, is it's what he wrote right here. He said, the California case alleges securities fraud by a Ripple executive. So the point being, the key takeaway, the reason this XRP lawsuit isn't as severe as the one the SEC filed in 2020 is because this lawsuit is alleging things that are of less consequence for the typical XRP holder. Again, because the case here, dating back to 2018, so this will be a new trial based on an old lawsuit. The California case, that's what we're talking about. Again, it's alleging that securities fraud by a Ripple executive. There isn't anything in there that would have broader implications for XRP holders just based on the charges alone. So, we don't want anything adverse. Why would we? But is this something that's going to destroy us? No. I mean, you're talking about Judge Torres more on a federal level. That's what matters. Her dicta that stated that XRP itself is not a security. That's what matters. And so, but somebody in the community is asking, okay, so XRP does not have regulatory clarity after all, and the Torres ruling doesn't mean anything in any other state, right? And we are back at square one, and so that's what, and there are many comments like this. There's an XRP community member going by the name Stillman, and so perfectly understandable why somebody would be asking that, and I think the answer is pretty well no, but here's what attorney Fred Rispoli said to that. He said, sadly, it depends. XRP, via Judge Torres, has legal clarity only, one, as it involves the SEC making allegations of federal securities violations, and two, in the Southern District of New York, which other courts can ignore in non-SEC cases. So a win, but not a nationwide win. And so that's a key takeaway. I'm glad he mentioned that. In terms of what this would mean and how it's going to impact other judges, well, if it's not an SEC case, and in this case, it's not an SEC case. It's a class action lawsuit. And then he says, and Ripple will always argue the SEC loss applies to any federal securities issue with XRP, res judicata in the legal world. But while that is a solid argument, it is not a slam dunk. And so you can see there's a bit of disagreement between these attorneys, but just me not being a lawyer, but reading this and doing my best like every other XRP community member, just to wrap my head around this, it doesn't appear to me that this is something that is going to screw us this bull run or anything to that effect. If that is the case, I haven't been sufficiently convinced. It hasn't been conveyed in that way. And the way that these lawyers are talking, I don't think that's the case. It could be bad. And again, like I just showed you, you can see there's a bit of different opinion here, and that's fine. It's all healthy and good to have civil discourse. But at this particular moment in time, I'm not seeing anything that's a red flag. But let's go ahead and run through some of this too, some of this CoinDesk article, so I can get you some more specifics about what the breakdown actually was here. And again, this headline is: California judge breaks with New York counterpart, sends Ripple securities lawsuit to trial. A California judge has ruled that a civil securities lawsuit against Ripple will proceed to trial, denying in part the crypto firm's motion for summary judgment in a suit alleging that Ripple CEO violated state securities laws in 2017. A jury will hear arguments on whether Ripple CEO Brad Garlinghouse made misleading statements in connection with the sale of securities in a 2017 televised interview. And so, folks, I think maybe one of the key takeaways here is, like, so even if they're going to find him guilty, they first need to analyze the Howey test and find that XRP satisfies that. But even then, what are they asking the judge to do? They're asking the judge to find that Ripple CEO Brad Garlinghouse did something wrong. So they're doing something to get to that conclusion. XRP isn't on trial here. And so when I was saying several minutes or so ago that the charges are different in these cases, and that's why it wouldn't be so consequential here for XRP holders, that's why. And so based on what I've seen from attorneys, that's what I believe is accurate. And so again, I've just been acting in good faith, doing my best to wrap my head around this. So if I read more stuff, I can certainly be swayed and be like, oh, maybe I was misunderstanding or missing something. I'm just being upfront about my understanding at this point, but I think that's the correct take at this particular moment, based on what I've seen so far. So this is not something that at this current moment I'm particularly worried about. But anyway, piece continues. The other 4 claims in the class action securities lawsuit, the so-called failure to register claims, were tossed out on Thursday by Judge Phyllis Hamilton of the U.S. District Court for the Northern District of California. We are pleased that the California court dismissed all class action claims. The one individual state law claim that survived will be dealt with at trial, said Ripple's chief legal officer Stu Alderati in an emailed statement. And folks, there's more from him a little bit later in this article, so stick around for that, because I'll just tell you this: he ain't worried about this. The plaintiff has alleged that Garlinghouse violated California's securities laws by professing to be very, very long XRP, while simultaneously selling millions of XRP on various cryptocurrency exchanges throughout 2017. According to court documents, Ripple's lawyers argued that the claim should be tossed because XRP doesn't meet the definition of a security under the Howey test and thus cannot give rise to a claim for misleading statements in connection with a security. In her Thursday ruling, Hamilton said that Ripple's lawyers urged her to follow the reasoning of U.S. District Court Judge Annalisa Torres, who in a parallel case in the Southern District of New York ruled that XRP did not meet all prongs of the Howey test when sold directly to retail participants on crypto exchanges. And so, folks, that goes back to what I was saying earlier in the video. If Ripple's selling on exchanges and you're buying it and you don't know it's Ripple, how are you in some sort of contract with Ripple? Like, just logically thinking through it, how are you relying on Ripple for anything if you don't know that you're even given the money? Anyway, piece continues. Torres' ruling constituted a partial victory for Ripple and was celebrated by many in the crypto industry as a step in the right direction for long-awaited regulatory clarity, as well as a potential precedent for other crypto securities cases. But Torres' ruling hasn't seemed to have as much sway as hopefuls once thought it might. I'll just pause to say that's debatable, as I just showed you. I showed you multiple perspectives from a few attorneys here, and even on the parts where they disagree, I wouldn't say there's some vast canyon of disagreement. Anyway, piece continues. But Torres' ruling hasn't seemed to have as much sway as hopefuls once thought it might. Last year, Torres' colleague in the SDNY District Judge Rakoff rejected her ruling in a separate case brought by the U.S. Securities and Exchange Commission against Singaporean crypto firm Terraform Labs. Hamilton, in her Thursday ruling, also broke with Torres' legal opinion that XRP sold to programmatic, meaning non-institutional traders, was not a security because those traders had no expectation of profits due to efforts of others, one of the 4 prongs of the Howey test. Now, I'll pause to note here, it's not that she's saying Judge Torres was wrong. It's more like she wasn't sufficiently persuaded. So that's not the same thing. And I think that's important there. And then I already cited that quote so I'm not going to read it again. It's at the screen, but I will read the how they wrap up this article. It says, in his statement, Alderati, so that's again Ripple's CLO, Chief Legal Officer, Alderati added that Torres' ruling in the SEC case, quote, still stands, end quote. And he also said, quote, nothing here disturbs that decision, end quote. And so Stu Alderati seems to think no matter what happens here, that it's not going to matter. So as far as XRP having legal clarity, and again, this is all I have from him so far. I haven't seen some sort of in-depth breakdown from Stu Alderati, but his perspective, so far as I can tell, I mean, it's on your screen there. He doesn't think that this is going to matter in the end. So, given that there's a lot of concern in the XRP community over this, and I'd say understandably so, I wanted to look into this as quickly as best as I could. This is what I found, and at this point in time, I just don't think it makes sense to be worrying about this stuff. So I'm sure there'll be more opinions and more stuff to say about this, but sleep easy. I think everything gonna be all right. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.